Ma'am, I said ID now. Stop playing games.
I've committed no violation. You have no lawful basis for this stop.
You're in an area known for illegal crossings, and you expect me to just assume you belong here?
I am a federal judge.
You are making a catastrophic mistake.
Judge Vanessa Sterling had been a federal judge for 12 years. She'd presided over hundreds of cases, interpreted constitutional law, and sworn an oath to uphold justice. But none of that mattered to the two ICE agents standing outside her car at a Shell gas station on a Tuesday morning. They saw a black woman in professional attire and made an assumption that would cost them everything. She was filling up her Mercedes before heading to the courthouse. The gas pump clicked. She replaced the nozzle. That's when the unmarked SUV pulled up behind her, blocking her exit. Two men stepped out wearing tactical vests with ICE printed across the chest. Agent Kyle Brennan and Agent Travis Mendoza had been with Immigration and Customs Enforcement for 8 and 6 years, respectively. They were about to make the biggest mistake of their careers. Judge Sterling asked again what violation justified the stop. Brennan repeated his demand for identification. His hand rested on his belt near his weapon. Mendoza circled around to the passenger side of her vehicle, peering through the windows. Other customers at the gas station started watching. Someone pulled out their phone. "I'm a federal judge. This stop is unconstitutional. You have no authority to detain me without reasonable suspicion of a crime." Brennan smirked. "Sure you are. And I'm the president. License and registration. Last time I'm asking nicely." What happened next would be dissected frame by frame in federal court. Judge Sterling, maintaining her composure despite the rage building inside her, slowly reached into her purse. She pulled out her judicial identification, the kind issued only to sitting federal judges, complete with her photo and the seal of the federal judiciary. She held it up clearly. Brennan glanced at it for maybe 2 seconds. He handed it back. "That doesn't mean anything. We still need to verify your immigration status." Judge Sterling's jaw tightened. "You just looked at federal judicial credentials and dismissed them. This is unlawful detention. I'm ordering you to step aside and let me leave." "You're not ordering us to do anything." Mendoza's voice came from behind her. "We have authority under federal immigration law to conduct stops and verify status. Not without individualized, reasonable suspicion you don't. And you certainly don't have authority over a sitting federal judge. This encounter is over." She moved toward her driver's door. Brennan stepped forward, blocking her path. His hand moved to his handcuffs. That's when Judge Sterling made the decision that would ultimately save her, but destroy them. She pulled out her cell phone and began recording. "I am Federal Judge Vanessa Sterling of the Northern District. I am being illegally detained by 2 ICE agents at the Shell station on Riverside Boulevard. I have presented my credentials. I have committed no violation. I am documenting this unconstitutional stop." "Turn off that phone." Brennan's voice rose. "You're interfering with a federal investigation." "I am the investigation, and this recording is evidence of your constitutional violations." Mendoza moved closer. His face appeared on camera. "Ma'am, if you don't comply right now, we will arrest you for obstruction." The absurdity of the threat hung in the air. 2 immigration agents threatening to arrest a federal judge for refusing an unlawful detention. But Brennan and Mendoza weren't thinking about consequences. They were thinking about control, about authority being challenged, about a black woman who wouldn't submit. Brennan grabbed Judge Sterling's wrist. The phone nearly dropped, but she held on. Mendoza moved in from the other side. Within seconds, they had forced her against her own vehicle. The phone was still recording, now capturing shaky footage of the gas station pavement and the agent's boots. "You are making a catastrophic mistake." Judge Sterling's voice remained steady, even as metal handcuffs closed around her wrists. "I am a federal judge. You are committing multiple federal crimes right now. Save it for processing." Brennan guided her toward their SUV. Other gas station customers stood frozen, watching a woman in a tailored suit being arrested at a fuel pump. 3 people were recording now. One man shouted, asking if she needed help. Mendoza told him to back away or face obstruction charges himself. The drive to the ICE field office took 19 minutes. Judge Sterling sat in the back seat, hands cuffed behind her, saying nothing. She had said everything that mattered already. Now she would let the system respond. And respond it would, with a force that Brennan and Mendoza couldn't begin to imagine. At the field office, they walked her inside like she was a dangerous criminal. Other agents glanced over with mild curiosity. Just another person being processed. Mendoza logged her into the system. Name, physical description, location of apprehension. He typed quickly, barely looking at the screen. Then came the part where they collect personal belongings. Judge Sterling's purse was emptied onto a metal table. Wallet, keys, lipstick, tissues, phone, and then the items that should have stopped everything immediately. Her judicial credentials, the ones Brennan had dismissed at the gas station. Her federal courthouse access badge with embedded security chip. Her Bar Association membership showing she'd been a licensed attorney for 23 years before her appointment to the bench. A business card identifying her as Judge Vanessa Sterling, U.S. District Court. The processing agent, a woman named Officer Rebecca Patel, picked up the credentials. She studied them carefully. She looked at Judge Sterling, then at Brennan and Mendoza, who were standing nearby filling out paperwork. "Did you see these?" Brennan barely looked up. "Yeah, they're fake." She claimed to be a federal judge, obviously lying. Patel had processed thousands of people. She knew what fake credentials looked like. These weren't fake. The holographic seals, the embedded security features, the weight of the cards, everything was authentic. She opened her computer and pulled up the Federal Judiciary Directory. "What's your full name and district?" "Judge Vanessa Sterling, Northern District." Patel typed. The search results loaded. There was the photo, matching the woman sitting in front of her. The biography listing her education, her appointment by the president 8 years ago, her confirmation by the Senate, recent cases she'd presided over. Everything matched. Patel's face went pale. She stood up slowly and walked directly to her supervisor's office. She didn't knock, just opened the door. Her supervisor, District Director Nathan Cross, looked up annoyed at the interruption. "We have a significant problem." 5 minutes later, Cross was standing in the processing area, staring at Judge Sterling. He'd pulled up the same federal directory on his own computer. He'd called the courthouse and confirmed she was scheduled to be in court that afternoon. He'd looked at Brennan and Mendoza's arrest report, which listed 0 specific violations, 0 reasonable suspicion, just vague references to an immigration verification stop. Cross had been with ICE for 15 years. He'd navigated political controversies, policy changes, and public scrutiny. But he'd never dealt with anything like this. His agents had just arrested a sitting federal judge without a warrant, without cause, without any legal justification whatsoever. "Release her immediately." His voice was quiet but sharp. "Remove the handcuffs, return all her belongings, and someone get me the agency's legal counsel on the phone right now." Judge Sterling stood as the handcuffs came off. She rubbed her wrists where the metal had pressed into her skin. She collected her belongings methodically, checking that everything was present. Her phone, still containing the recording. Her credentials, now validated. Her dignity, somehow intact despite everything. Cross approached carefully. "Your Honor, I apologize for this incident. There's been a serious misunderstanding." "Director Cross, there was no misunderstanding. Your agents conducted an unlawful stop, ignored federal credentials, and arrested a sitting federal judge. Those are facts, not misunderstandings. We'll be conducting a full internal investigation. You'll be facing a federal civil rights lawsuit and likely criminal charges for violating my constitutional rights under color of law." She walked toward the exit. Brennan and Mendoza stood against the wall, finally understanding that something had gone terribly wrong. Judge Sterling paused and looked directly at them. "You'll be hearing from me again. In court." The door closed behind Judge Sterling with a soft click that somehow felt louder than any slam could have been. She stood outside the ICE facility in the harsh afternoon sunlight, free, but fundamentally changed by what had just happened. Her phone buzzed immediately. 17 missed calls, 42 text messages. Her clerk, her staff, the courthouse security, all wondering where she was. She had missed an entire afternoon of scheduled hearings, cases that mattered, people whose lives depended on her rulings, left waiting while she sat handcuffed in a processing room for the crime of existing in her own skin. She didn't call anyone back yet. Instead, she opened the voice recording app on her phone. The file was still there. 23 minutes and 14 seconds of audio capturing every word spoken during that traffic stop. Every illegal question. Every ignored credential. Every moment of her constitutional rights being violated by federal agents who should have known better. Judge Sterling walked to her car, still parked exactly where Brennan had forced her to leave it. A parking ticket fluttered under the windshield wiper. Even that felt like a final insult. She pulled it out and actually laughed, a sharp, bitter sound that surprised her. Arrested without cause and ticketed for the privilege. The drive back to the courthouse took 30 minutes through heavy traffic. She used the time to think, to plan, to shift from victim back to judge. Because that's what she was, regardless of what agents Brennan and Mendoza saw when they looked at her. A federal judge with the full power of the judiciary behind her. When she arrived, the courthouse was in controlled chaos. Her clerk practically ran to meet her at the entrance. "Judge Sterling, we've been trying to reach you for hours. Are you all right? What happened?" "Reschedule everything from this afternoon, clear my calendar for tomorrow morning, and get me the contact information for the Department of Justice Office of Professional Responsibility and the Inspector General for Homeland Security." Her chambers felt different when she entered. The same mahogany desk, the same leather chair, the same law books lining the walls. But she wasn't the same person who had left that morning. Something had shifted. The theoretical cases she presided over, the abstract questions of constitutional law and civil rights, they weren't abstract anymore. They were personal. They were real. They were burned into her wrists where the handcuffs had been. She spent the next 4 hours making calls. The first was to her husband, a college professor who listened in stunned silence as she explained what happened. The second was to her attorney, because even judges need lawyers when their rights are violated. The third was to the chief judge of her district, because this wasn't just a personal matter. This was an assault on the judiciary itself. By 7 that evening, the machinery of justice had begun its grinding work. The Department of Justice opened a preliminary inquiry. The Inspector General's office assigned investigators. The chief judge issued a statement expressing grave concern and demanding a full accounting. And Judge Sterling's attorney filed a notice of intent to sue, the first step toward a federal civil rights lawsuit that would cost the government far more than money. But that was just the official response. The unofficial response was spreading through the legal community like wildfire. Judges talked to other judges. Attorneys shared the story with colleagues. Law clerks posted about it on private forums. By the next morning, every legal professional in the district knew that 2 ICE agents had arrested a sitting federal judge, and the implications were staggering. Meanwhile, back at the ICE facility, Director Cross was having the worst night of his career. He sat in his office reviewing the arrest report for the 100th time, searching for anything that might justify what his agents had done. There was nothing. No warrant, no probable cause, no reasonable suspicion. Just 2 agents who saw a black woman and decided that was sufficient reason to demand papers and make an arrest when she objected. The agency's legal counsel had been brutally clear. This case was indefensible. The agents had violated clearly established constitutional rights. Qualified immunity wouldn't protect them. The agency would likely lose any lawsuit. The only question was how much it would cost. Cross called Brennan and Mendoza into his office at 6 the next morning. Both agents arrived looking exhausted. Word had spread through the facility about exactly who they had arrested, and neither had slept well. "You're both suspended without pay, effective immediately. You'll surrender your badges and firearms. You're prohibited from discussing this case with anyone except your attorneys and our investigators. Do you understand?" Brennan's jaw tightened. This is political correctness gone crazy. We were doing our jobs. Your job doesn't include arresting federal judges without cause. Your job doesn't include ignoring valid credentials. Your job doesn't include violating constitutional rights. She showed us a fake ID. Anyone can print a card. Cross slid a printed page across the desk. It was Judge Sterling's official biography from the federal judiciary website, complete with her photo, her credentials, her 8 years on the bench. Anyone can print a card, but not anyone can have their photo and biography on the official federal court website. Not anyone can be listed in the National Judiciary Database. You didn't check because you didn't want to believe her. Mendoza spoke for the first time. What happens now? Now you get attorneys. Good ones. Because the Department of Justice is investigating you for civil rights violations under color of law. That's a federal felony. And Judge Sterling will be filing a civil lawsuit. You're both looking at criminal charges and personal financial liability. The color drained from Mendoza's face. We could go to prison? Cross nodded. People have gone to prison for less egregious violations than arresting a federal judge without cause. The investigation moved quickly because the evidence was overwhelming. The dashboard camera from the ICE vehicle showed the entire stop. Judge Sterling's phone recording captured every conversation. The processing paperwork documented the arrest. There were no gaps, no ambiguities, no questions about what happened. Within 2 weeks, the Department of Justice made its decision. Criminal charges would be filed against both agents: deprivation of rights under color of law, false arrest, and abuse of authority. Each charge carried potential prison time. The civil lawsuit followed shortly after. Judge Sterling's attorney filed a comprehensive complaint in federal court. It named Brennan and Mendoza individually, named ICE as an agency, and named the Department of Homeland Security. The damages sought were substantial, but the complaint made clear this wasn't primarily about money. It was about accountability. The case was randomly assigned to another federal judge in the same district. Judge Thomas Crawford had served on the bench for 12 years and knew Judge Sterling professionally. He read the complaint with increasing disbelief, then reviewed the evidence attached as exhibits. The recordings, the video, the documented timeline. Everything confirmed exactly what the complaint alleged. This will not be a long trial, he thought. This will be a settlement negotiation. He was right. The government's attorneys reviewed the same evidence and reached the same conclusion. They had no defense. Their own agents' actions were documented beyond any possibility of dispute. Going to trial would mean playing that dashboard camera footage for a jury, letting them hear 2 federal agents dismiss a judge's credentials as fake, watching them arrest her without legal justification. Settlement discussions began within a month. The government offered $500,000. Judge Sterling's attorney countered with $2.5 million. Not because Judge Sterling needed the money, but because the number had to be large enough to hurt, to force systemic change, to make sure this never happened to anyone else. The negotiations continued for weeks. Meanwhile, the criminal case moved forward on a parallel track. Brennan and Mendoza both retained private attorneys using their life savings. Both were advised to consider plea agreements because taking these charges to trial was effectively suicide. Brennan refused. He maintained he'd done nothing wrong, that he was being persecuted for enforcing immigration law. His attorney told him he was making a catastrophic mistake. Brennan fired his attorney and hired another one, who told him the same thing. Mendoza was more realistic. She understood that the evidence was damning, that her career was over, that her only hope of avoiding significant prison time was cooperation. Her attorney negotiated a plea deal. Mendoza would plead guilty to 1 count of deprivation of rights under color of law. She would testify against Brennan if his case went to trial. In exchange, prosecutors would recommend probation instead of prison. She took the deal. Standing in federal court, ironically just 2 floors below where Judge Sterling's chambers were located, Mendoza pleaded guilty. She admitted that she had participated in an unlawful stop and arrest. She acknowledged violating Judge Sterling's constitutional rights. She accepted responsibility for her actions. Judge Crawford, presiding over the plea hearing, asked if she understood what she was admitting. Mendoza said yes. He asked if anyone had forced or coerced her plea. She said no. He accepted the guilty plea and scheduled sentencing for 3 months later. Brennan watched all of this happen and still refused to accept reality. His new attorney begged him to reconsider. The evidence was overwhelming. His former partner had turned against him. He was going to lose at trial and face years in federal prison. "Please," his attorney said, "take a deal while there's still time." Brennan refused. He would take his chances with a jury. He believed 12 ordinary citizens would understand he was just doing his job, just following procedures, just trying to enforce the law. His attorney knew better, but couldn't force him to see reason. The civil settlement was finally reached 4 months after the arrest. The government agreed to pay Judge Sterling $1.8 million. More importantly, they agreed to policy changes. All federal agencies would implement mandatory training on implicit bias and proper identification verification. Dashboard cameras would be reviewed quarterly for constitutional violations. Agents who made unlawful stops would face immediate suspension pending investigation. The settlement terms were made public, and the dollar amount made headlines. But Judge Sterling cared more about the policy changes. She wanted to prevent this from happening again, to the next person, to someone who didn't have her resources or legal knowledge. The criminal trial against Brennan began 6 months after the arrest. The courtroom was packed. Local media filled the gallery. Civil rights organizations sent observers. Federal employees came to watch one of their own face justice. The prosecution's case was devastating from the opening statement. They walked the jury through every moment of that traffic stop. They explained how Judge Sterling had done nothing wrong, had presented valid credentials, had asked reasonable questions. They showed how Brennan ignored all evidence contradicting his assumptions, how he invented justifications after the fact, how he arrested a federal judge for the crime of questioning his authority. The dashboard camera footage played on large monitors. Every juror watched as Brennan dismissed Judge Sterling's credentials without even examining them properly. They heard him tell her to stop talking, to stop asking questions, to comply or face arrest. They saw him handcuff a woman who had committed no violation whatsoever. The prosecution called Mendoza as a witness. She testified for 3 hours. She explained that she had tried to tell Brennan they should verify the credentials. She admitted she should have tried harder, should have insisted, should have refused to participate. She acknowledged her own guilt, but made clear that Brennan had been the driving force behind everything that happened. Cross-examination was brutal. Brennan's attorney tried to paint Mendoza as a liar trying to save herself. He suggested she was the one who wanted to make the arrest and was now blaming Brennan. But the dashboard footage contradicted everything he claimed. The video showed exactly who made each decision, who gave each command, who chose escalation over verification. Expert witnesses testified about proper law enforcement procedures. A former ICE supervisor explained that Brennan had violated every protocol designed to prevent exactly this kind of mistake. A constitutional law professor walked the jury through the Fourth Amendment, explaining how Brennan's actions constituted a clear violation of Judge Sterling's rights. Judge Sterling herself took the stand. She described the humiliation of being arrested in her own vehicle. She explained how she had remained calm despite knowing she was being unlawfully detained. She recounted the fear she felt, not physical fear, but fear that anything she did or said would be used to justify violence against her. The defense tried to suggest Judge Sterling had been uncooperative, that she had escalated the situation by asking questions. Her attorney objected immediately. Asking questions is not a crime. Asserting your rights is not obstruction. The judge sustained the objection and instructed the jury to disregard the implication. Brennan took the stand in his own defense. His attorney had advised against it, but Brennan insisted. He needed to explain himself, to make the jury understand. His testimony was a disaster. He claimed he had reasonable suspicion based on Judge Sterling's presence in a high-traffic area for undocumented individuals. The prosecution immediately challenged this. What high-traffic area? A residential street in a middle-class neighborhood? Brennan couldn't provide specifics. He said Judge Sterling seemed nervous. The dashboard footage showed her perfectly calm. He claimed her credentials looked suspicious. He couldn't articulate what specifically seemed suspicious about valid federal documents. The prosecution destroyed him on cross-examination. They played the video again, pausing at key moments. When exactly did you verify these credentials before dismissing them? Brennan admitted he hadn't run them through any system. Did you call the courthouse to confirm Judge Sterling's identity? No. Did you consult a supervisor before making the arrest? No. Did Judge Sterling commit any traffic violation that justified the initial stop? A long pause. No. So you stopped her based on what exactly? Another pause. Her appearance in that area at that time. Her appearance, yes. And what about her appearance made you suspicious? Brennan realized the trap too late. There was no answer he could give that wouldn't sound like exactly what it was. The jury deliberated for 4 hours. They returned guilty verdicts on both counts: deprivation of rights under color of law and making false statements in official reports. Brennan sat motionless as the verdicts were read. His attorney placed a hand on his shoulder, but Brennan didn't react. Sentencing was scheduled for 2 months later. Brennan remained free on bond until then, but his life as he knew it was over. The federal conviction meant he could never work in law enforcement again. His pension was forfeit. His reputation was destroyed. Mendoza's sentencing came first. She stood before Judge Crawford, the same judge who had accepted her guilty plea. Her attorney presented letters from family and colleagues describing her years of service, her previously clean record, her genuine remorse. Mendoza herself addressed the court. She apologized to Judge Sterling, who sat in the gallery. She acknowledged that following orders was not an excuse, that she had her own moral responsibility to refuse unlawful commands. She said she would spend the rest of her life trying to make amends. Judge Crawford sentenced her to 3 years of probation, 500 hours of community service, and a $10,000 fine. He noted that her cooperation and genuine remorse weighed heavily in his decision, but emphasized that what she did was serious, that she had betrayed her oath and violated someone's fundamental rights. Mendoza accepted the sentence without appeal. Brennan's sentencing 2 weeks later was entirely different. He showed no remorse. His attorney presented a sentencing memorandum arguing that Brennan had acted in good faith, that mistakes happen in law enforcement, that prison time would be excessive. The prosecution's memorandum told a different story. It detailed Brennan's history of complaints, the pattern of stops targeting people of color, the multiple warnings from supervisors that he had ignored. This was not one mistake. This was a pattern of constitutional violations that finally caught up with him. Judge Sterling submitted a victim impact statement. She described the lasting effects of being treated like a criminal in her own community. She explained how she still felt anxiety during any interaction with law enforcement, how the arrest had undermined her sense of safety and belonging. She noted that as a judge, she understood the legal system better than most victims, yet still felt powerless in that moment. What about people without her knowledge, resources, or position? How many others had Brennan violated who never got justice? Judge Crawford read the entire statement aloud in court. Then he addressed Brennan directly. You were given authority and power to serve your community. You abused that power. You targeted someone based on assumptions and bias, then arrested her when she dared to question you. Even now, after a jury convicted you, you show no understanding of what you did wrong. That concerns me deeply. The sentence was harsh. 30 months in federal prison, 3 years of supervised release following incarceration, a $50,000 fine, restitution to Judge Sterling for attorney fees and costs. Brennan's attorney immediately filed notice of appeal, but everyone in that courtroom knew it was futile. The evidence was overwhelming, the verdict sound, the sentence within guidelines. The appeal would fail. Brennan was taken into custody immediately. No more freedom while waiting, No more chances to flee or influence anyone. Federal marshals placed him in handcuffs and led him out of the courtroom. The same handcuffs he had placed on Judge Sterling now bound his own wrists. The symmetry was not lost on anyone present. Judge Sterling watched him leave. She felt no satisfaction, no sense of victory, just exhaustion and sadness that it had come to this, that someone entrusted with authority had abused it so thoroughly. Outside the courthouse, reporters surrounded her. She made a brief statement. Justice has been served, but justice delayed is justice diminished. This should never have happened. The system failed long before that traffic stop. Multiple complaints were ignored, warning signs dismissed, patterns overlooked. Real accountability means preventing these violations, not just punishing them after the damage is done. The reporters dispersed within minutes, but the real fallout was just beginning. Within 24 hours, a civil rights organization filed a class action lawsuit against the entire police department. They had compiled records going back 7 years, showing systematic patterns of racial profiling, unlawful stops, and retaliatory arrests. Judge Sterling's case wasn't unique. It was just the one that finally made headlines because of who she was. The lawsuit identified 43 other victims. A teacher arrested for jaywalking after questioning why an officer stopped him. A nurse detained for suspicious behavior while sitting in her own car outside her apartment. A college student handcuffed for matching the description of a suspect who was 6 inches shorter and 30 pounds heavier. A grandfather tackled during a wellness check his own daughter had requested. Every single victim was Black or Latino. Every single officer involved had complaint histories that were ignored. The patterns were undeniable once someone actually looked. But here's what made it worse. Internal Affairs had the data all along. They knew which officers generated the most complaints. They knew which precincts had the highest rates of use of force against minorities. They knew supervisors were signing off on questionable arrests without proper review. They simply chose not to act because acting would mean admitting there was a problem. And admitting problems meant liability, bad press, budget fights, political headaches. So they buried it. Filed reports in databases no one searched. Marked complaints as unfounded without real investigation. Transferred problem officers to different districts instead of firing them. The system protected itself while the community suffered. The discovery process in the class action revealed emails that should never have been written. Supervisors joking about arrest quotas in certain neighborhoods. Officers sharing memes mocking people they had detained. A lieutenant telling subordinates to find reasons to stop people in high-crime areas, which was code everyone understood. The department's own training materials included outdated techniques that civil rights experts said practically encouraged constitutional violations. None of this was accidental. It was institutional rot that had been festering for decades. Judge Sterling became the face of the lawsuit, though she never wanted that role. She gave depositions, appeared at hearings, testified before city council. Every appearance meant reliving that traffic stop, answering questions about how it felt, explaining the fear and humiliation over and over. She did it anyway, because the 43 other victims deserved someone with her platform fighting alongside them. Most of them didn't have legal backgrounds. Most couldn't afford the kind of attorneys this case required. Most would have been ignored if they had tried fighting alone. The city's defense strategy was predictable. They claimed these were isolated incidents by officers who didn't represent department values. They pointed to diversity training programs and community outreach initiatives as proof they took these issues seriously. They argued that policing is difficult, that split-second decisions sometimes go wrong, that hindsight is 20/20. Their attorneys painted the officers as dedicated public servants who made honest mistakes under pressure. The problem was the evidence. Thousands of pages of data showing the mistakes somehow always happened to the same communities. Video footage from body cameras and dash cams showing officers lying in their reports. Testimony from sergeants admitting they approved arrests without reviewing the facts because they trusted their officers' judgment. That trust was misplaced, and now the city was paying for it. 18 months after the lawsuit was filed, the city settled. $230 million, split among the 43 victims and their attorneys. Comprehensive reforms, including independent oversight, mandatory body cameras that couldn't be turned off, automatic review of any arrest where charges were dropped, and termination for officers who filed false reports. The police union fought every single reform, claiming they would make officers hesitant to act, that crime would skyrocket, that good cops would leave the force. Some did leave. Most stayed. Crime didn't increase. Complaints dropped by 60% within the first year. Judge Sterling received $4.7 million from the settlement. She donated $3 million to organizations supporting criminal justice reform. She used another $1 million to establish a legal defense fund for people who couldn't afford attorneys when challenging unlawful arrests. She kept the rest, not because she needed it, but because accepting it meant the city officially acknowledged what they had done to her. The money was accountability in its most tangible form. Brennan served 22 months before being released to a halfway house. Federal prisoners typically serve 85% of their sentence if they behave, and Brennan kept his head down. He worked in the prison library, took classes, stayed out of trouble. He never admitted guilt, never expressed genuine remorse, but he learned to say the right things during parole hearings. When he was finally released, he moved to a different state where no one knew his name or his history. He couldn't work in law enforcement anymore. His conviction made that impossible. He took a job doing private security at a warehouse, checking badges and watching cameras. The irony of a man who abused authority, now working minimum wage security, wasn't lost on anyone who knew his story. Mendoza had a different trajectory. Her cooperation and genuine remorse opened doors Brennan's defiance had closed. After completing probation, she became an advocate. She spoke at police academies about what she had done wrong and why. She testified before legislative committees considering reforms. She met with community groups who had every reason to hate her and answered their questions honestly, no matter how uncomfortable. Some people forgave her. Many didn't. She accepted both responses as consequences she had earned. Judge Sterling returned to the bench 6 months after the settlement. Some questioned whether she could be impartial in cases involving police testimony. She proved them wrong by ruling based on evidence, not emotion. She convicted defendants when the evidence warranted it and acquitted them when it didn't. She held officers accountable when they lied and credited them when they testified truthfully. Her experience made her better at her job, not worse. She could spot inconsistencies in police reports that other judges missed. She asked questions that revealed whether an officer truly had probable cause or was justifying a hunch. Defense attorneys requested her courtroom. Prosecutors learned they needed solid cases, not just a badge and a story. 3 years after the traffic stop, a reporter asked Judge Sterling if she thought anything good had come from what happened to her. She considered the question carefully before answering. Good isn't the word I would use. Necessary, maybe. My case forced changes that should have happened decades ago. But those changes came at a cost to me and 43 other people who never should have been violated in the first place. We shouldn't need federal judges to be unlawfully arrested before the system takes these problems seriously. We shouldn't need viral videos and lawsuits and public outrage before basic constitutional rights are protected. The fact that we do tells you everything about how broken things were. The police department still exists. Officers still make traffic stops. Arrests still happen. But the culture shifted in ways both measurable and subtle. Officers know their body cameras are recording and will be reviewed. Supervisors know signing off on bad arrests will cost them their jobs. The community knows they can file complaints that will actually be investigated. None of it is perfect. Systems created over decades don't transform overnight. But the trajectory changed, and that matters. Brennan's appeal failed, as predicted. His conviction stands. His prison sentence is public record. Anyone searching his name finds the full story of what he did and what it cost him. That permanent stain is part of his punishment, a reminder that authority without accountability eventually destroys those who abuse it. Some officers learned from his example. Others resented it, viewing him as a scapegoat for systemic problems. Both reactions missed the point. Brennan wasn't a scapegoat. He was someone who violated rights repeatedly until he finally faced consequences. The system that enabled him for so long deserved scrutiny too, and it got that scrutiny through the lawsuit and reforms that followed. Judge Sterling still drives past the intersection where Brennan pulled her over. She doesn't avoid it or take alternate routes. That corner doesn't own her. She reclaimed it by refusing to let what happened there define her or limit her movements. Sometimes she thinks about that moment, the lights in her mirror, the sinking feeling in her stomach. Then she keeps driving, exactly where she needs to go. That gas station on Riverside Boulevard still operates. People fill up their tanks every day, unaware of the history that unfolded on that concrete. But for Judge Sterling, for Brennan, for Mendoza, for the 43 other victims whose names never made headlines, that intersection represents something permanent. It's a reminder that badges don't grant immunity from consequences, that cameras capture truth that reports can't hide, that justice delayed is still justice when it finally arrives. The system failed repeatedly before it worked. Complaints ignored, patterns dismissed, violations rewarded with promotions instead of punishment. It took a federal judge being handcuffed at a fuel pump before anyone with power decided enough was enough. That reality should disturb everyone watching this, because it means countless others suffered without remedy, without witness, without the platform to force change. Real accountability isn't one verdict or one settlement. It's cultural transformation that makes these violations unthinkable instead of routine. Now, watching footage like this, it can really stick with you, right? Some of these clips stay in your head, especially late at night when you're trying to fall asleep. And speaking of sleep, a lot of you have told me you're waking up at 2 or 3 a.m. and just lying there. Can't shut your mind off. And the next day you're dragging through everything. I came across a simple 21-day sleep guide that's helped thousands of people fix exactly that. No pills, no apps, no gadgets. Just a step-by-step plan that actually works. It's only $15. I put the link in the description if you want to check it out. All right, I'll catch you in the next one.
Turn around, now! You fit the description and I'm not arguing about it.
Sir, I've done nothing wrong. You can verify my identity through dispatch.
Don't start talking like you're above this. I know what I'm looking at.
You're looking at a federal judge.
I don't care who you claim to be. Turn around!
The handcuffs click shut around her wrists at 9:47 p.m. Judge Claudia Brennan, a federal district court judge with 17 years on the bench, stood in the fluorescent glow of a gas station parking lot, arms pulled behind her back, while Officer Dennis Kovac told her to stop resisting. She wasn't resisting. She was asking questions, and apparently that was enough. This wasn't a case of mistaken identity. This wasn't a misunderstanding that would get cleared up in 5 minutes. This was a veteran police officer looking at a black woman in business attire pumping gas and deciding she must be a criminal. What happened next would trigger a Department of Justice investigation, destroy multiple careers, and send a clear message about what happens when you handcuff a federal judge for absolutely no reason. The gas station sat on the corner of Westfield Avenue and Route 22, one of those brightly lit spots that stays open all night, serving coffee and lottery tickets to whoever needs them. Judge Brennan had stopped there after working late at the courthouse, reviewing case files for a complex fraud trial set to begin the following week. She wore a navy blue suit, her judicial robes long since hung up in her chambers. Her car, a silver sedan, sat at pump number 4. Officer Kovac pulled into the gas station at 9:43 p.m., 4 minutes before everything went sideways. He was responding to a call about a stolen vehicle in the area. The description was minimal. A dark-colored sedan, possibly silver or gray, occupied by a black female. No plate number, no make or model, no distinguishing features. Just those few details broadcast over the radio 20 minutes earlier. Kovac scanned the gas station and saw Judge Brennan's vehicle. Silver sedan, black woman. In his mind, that was probable cause. He didn't run the plates. He didn't call for backup. He didn't observe any suspicious behavior. He simply decided this must be his suspect and approached with his hand already resting on his duty weapon. Judge Brennan noticed the patrol car but thought nothing of it. Police stopped at this station regularly. She finished pumping her gas, replaced the nozzle, and was reaching for her receipt when Kovac's voice cut through the night air. He ordered her to step away from the vehicle and put her hands where he could see them. She turned, confused. The officer was standing 15 feet away, positioned behind his open car door, hand still on his weapon. Judge Brennan asked what the problem was. Simple question, reasonable under the circumstances. Kovac's response was to repeat his command, louder this time, telling her this was her last warning before he considered her non-compliant. Here's what Judge Brennan did next, and pay attention because this part matters. She calmly stated her name and title. She explained she was a federal judge returning home from work. She offered to show identification. She suggested the officer verify her identity through dispatch. She kept her hands visible. Her voice remained steady. Everything she did was textbook de-escalation. Kovac heard none of it. Or rather, he heard it and decided it was a lie. In his mind, criminals claim to be anything when confronted. Doctor, lawyer, judge, whatever might get them out of trouble. The more insistent she became about her identity, the more convinced he grew that she was lying. He told her to turn around and place her hands behind her back. Judge Brennan asked to speak with a supervisor. Kovac said she could do that at the station. She asked what crime she was suspected of committing. Kovac said she matched the description of a suspect. She asked what description. He told her to stop talking and comply. The gas station security cameras captured everything. The footage would later become Exhibit A in multiple investigations. It showed Judge Brennan standing completely still, hands raised to shoulder height, while Kovac approached from behind. It showed him pulling her arms down roughly. It showed the handcuffs going on. It showed her being walked to the patrol car, while other customers watched in stunned silence. A man filling up his truck at the next pump called out, asking if everything was all right. Kovac told him to mind his business. A teenager working the register inside came to the door, phone already out and recording. Kovac didn't stop him, but his jaw tightened when he noticed. Judge Brennan was placed in the back of the patrol car at 9:51 p.m. 4 minutes from first contact to arrest. 4 minutes to destroy a career and trigger a federal civil rights investigation. The back seat smelled like industrial cleaner trying to mask something worse. The plastic seat was cracked and uncomfortable. Judge Brennan sat perfectly upright, staring straight ahead, her mind already working through what would happen next. She had sentenced people from her bench for civil rights violations. She had written opinions on unlawful detention and qualified immunity. She had lectured at law schools about Fourth Amendment protections. And now she was experiencing the other side of the system, handcuffed in a police car because an officer saw her skin color before he saw anything else. Kovac climbed into the driver's seat and picked up his radio. He reported that he had detained a suspect matching the description of the stolen vehicle call. Dispatch asked if he had confirmed the vehicle was stolen. Kovac said he was transporting the suspect to the station for processing. Dispatch asked again about the vehicle confirmation. Kovac didn't answer. The drive to the station took 8 minutes. Judge Brennan didn't speak. Kovac didn't either. The radio crackled with routine traffic. Another unit responding to a noise complaint. Someone requesting a tow truck. The mundane business of a Tuesday night, while a federal judge sat handcuffed in the back, her credentials sitting in her purse, her judicial ID in her wallet, all of it ignored. They arrived at the station at 10:03 p.m. Kovac walked Judge Brennan inside through the side entrance used for processing arrests. The booking area was busy with the usual evening chaos. 2 officers finishing paperwork. A woman arguing with someone on her phone. A man sleeping on a bench, apparently waiting for someone. Nobody looked twice at Kovac bringing in another arrest. The officer working the booking desk was named Sergeant Phyllis Dunham. She had 22 years on the force and had processed thousands of arrests. She was the first person that night who actually listened. When Kovac explained he had arrested a woman matching the description of a stolen vehicle suspect, Dunham asked to see the vehicle report. Kovac handed it over. Dunham read it slowly. Then she looked at Judge Brennan, still standing there in handcuffs, wearing a business suit that probably cost more than Dunham made in a week. Something didn't add up. Dunham asked Kovac if he had confirmed the vehicle was actually stolen. He said he was bringing the suspect in for questioning first. Dunham asked if he had run the plates. The silence that followed answered her question. She turned to Judge Brennan and asked for her name. Judge Brennan provided it, along with her title. Dunham's eyes widened slightly. She asked if Judge Brennan had identification. The response was yes, in her purse, which was still in her vehicle back at the gas station. Dunham looked at Kovac with an expression that clearly communicated what she thought of his police work. Dunham excused herself and walked directly to the watch commander's office. Lieutenant Victor Salazar was finishing reports when Dunham knocked. The conversation that followed lasted less than 2 minutes, but Salazar's face went through several distinct phases. Confusion, disbelief, anger. The kind of anger that comes from knowing your department is about to be destroyed in the press and the courts. Salazar came down to the booking area personally. He looked at Judge Brennan, still in handcuffs. He looked at Kovac, still convinced he'd done solid police work. Salazar asked one question. Did you confirm anything before making this arrest? Kovac started to explain his reasoning, but Salazar cut him off. The handcuffs came off Judge Brennan's wrists at 10:18 p.m., 31 minutes after they went on. Salazar apologized repeatedly while Dunham documented everything. Judge Brennan remained composed, but her first request made everyone in that booking area go silent. She wanted every piece of documentation related to her detention. Every report, every radio communication, every camera angle from the gas station and the police station. She wanted names, badge numbers, and the chain of command notifications. Salazar knew exactly what that meant. This wasn't going away quietly. Judge Brennan made one phone call from the station. Not to a lawyer, though she was one herself. Not to family. She called the chief judge of the federal district court, Margaret Holloway, who had appointed her to the bench 6 years earlier. The call lasted 90 seconds. Holloway's only response was a quiet, "I see," followed by, "Document everything. I'll handle the rest." By midnight, 3 things happened simultaneously. The Department of Justice received formal notification of a federal judge's unlawful detention. The state attorney general's office got a courtesy heads-up that something significant was brewing. And the police chief, Raymond Foster, got woken up at home by a phone call that made him seriously consider early retirement. Foster arrived at the station at 12:40 a.m., wearing sweatpants and a department jacket. His first stop was Lieutenant Salazar's office, where he watched the gas station security footage. Then, the dash cam from Kovac's cruiser. Then, the body cam that Kovac apparently forgot he was wearing. Each video made Foster's expression darker. The facts were undeniable. Kovac had no reasonable suspicion. The vehicle wasn't stolen. The plates came back clean. Judge Brennan identified herself immediately. She offered her credentials. She asked for a supervisor. She complied with every command despite having zero legal obligation to do so. And Kovac arrested her anyway because in his mind, a black woman in an expensive car at night must be a criminal. Foster called Kovac into the office. The officer still thought he might get praised for being proactive. Instead, Foster suspended him on the spot. Badge and weapons surrendered immediately. Kovac started to argue, to explain his reasoning, but Foster wasn't interested. He'd seen enough officers destroy their careers through stupidity, but this was exceptional, even by those standards. Judge Brennan left the station at 1:15 a.m. She drove herself home in the same vehicle Kovac claimed was suspicious. The irony wasn't lost on anyone. She didn't speak to the press waiting outside, didn't make a statement, just walked to her car with the same composed dignity she'd maintained throughout the entire ordeal. But composed didn't mean she was letting this go. Not even close. The next morning, Judge Brennan did something she'd never done in 6 years on the bench. She recused herself from every case on her docket for the next 2 weeks. Her clerk made the notifications. Lawyers scrambled to adjust. Other judges absorbed her cases. The legal community started asking questions. By noon, the story broke. Not because Judge Brennan leaked it. She didn't have to. Someone at the station talked. Then someone else. Then the gas station owner who'd watched the whole thing reviewed his security footage and decided the public needed to see what he saw. The footage hit social media before any official statement came out. The response was immediate and volcanic. Civil rights organizations issued statements. The State Bar Association expressed concern. Other federal judges, who normally stayed out of public controversies, made it known they were watching closely. Legal scholars wrote op-eds about judicial independence and police overreach. The story wasn't just local anymore. It was national. The police department tried damage control. They issued a statement about taking the matter seriously and conducting a thorough investigation. The words rang hollow. Everyone knew what the investigation would find because everyone had seen the videos. Kovac, sitting at home on suspension, still didn't fully grasp what he'd done. He told friends he was being thrown under the bus for political reasons, that he'd followed procedure, that anyone would have made the same call. He genuinely believed he was the victim here, punished for doing his job, in a world where police couldn't win no matter what they did. Meanwhile, Judge Brennan was building her case. Not in court yet. That would come. First, she documented everything. She wrote a detailed timeline from memory while it was fresh. She compiled every interaction, every statement, every moment from pulling into that gas station to walking out of the police station. Her legal training meant she knew exactly what mattered and what didn't. She also did something unexpected. She requested records of every traffic stop Kovac had made in the past 3 years. Public records. Nothing requiring a warrant or subpoena. Just data that any citizen could access with the right request forms. The department had to comply. The patterns that emerged were damning. Kovac stopped black drivers at rates far exceeding his peers. His stops of black women specifically were off the charts. Most stops resulted in warnings or nothing at all, suggesting they lacked legitimate basis from the start. Several had generated complaints that went nowhere because they were marked unsubstantiated or unfounded. Judge Brennan wasn't the first person Kovac had done this to. She was just the first one with the resources, knowledge, and platform to do something about it. 2 weeks after the arrest, Judge Brennan filed a federal civil rights lawsuit. Not just against Kovac, against the department for inadequate training and supervision, against the city for policies that enabled this behavior, against everyone in the chain of command who'd seen Kovac's pattern and done nothing. The complaint was devastating. 43 pages of facts, legal theory, and documented evidence. It detailed not just what happened to Judge Brennan, but the systemic failures that made it possible. It included data showing Kovac's stop patterns. It referenced the complaints that were ignored. It outlined how supervisors failed to identify obvious problems. The legal community read it with something approaching awe. This wasn't just a lawsuit. It was a masterclass in federal civil rights litigation, written by someone who understood both sides of the bench. Judge Brennan had essentially written a blueprint for how these cases should be prosecuted. The city attorney read the complaint and immediately advised the mayor to settle. The case was unwinnable. The evidence was overwhelming. Taking it to trial meant putting Kovac on the stand, where he'd get destroyed on cross-examination. It meant the videos playing for a jury. It meant discovery that would expose every other problematic officer and policy the department had. But the mayor hesitated. Settling immediately looked like an admission of guilt. It looked weak. He wanted to fight, to defend the department, to show he supported law enforcement. The city attorney warned him this was a catastrophic miscalculation, but the mayor thought he knew better. That decision would haunt him. Judge Brennan's legal team, which now included 3 civil rights attorneys working pro bono, filed motion after motion. They requested everything: personnel files, training records, internal affairs investigations, use of force reports. They built a case that went far beyond one illegal arrest. They were going after the entire culture that made it possible. Discovery revealed things the department desperately didn't want public. Kovac had been flagged multiple times by supervisors for concerning behavior. Nothing was ever done. Other officers had complained about his aggressive approach. They were told to mind their business. Training on implicit bias was outdated and rarely enforced. The early warning system designed to catch problem officers was essentially ignored. The deeper the investigation went, the worse it got. This wasn't about one bad cop. It was about a department that enabled bad cops and ignored warning signs until something exactly like this happened. Judge Brennan watched it unfold with the same calm she'd shown in that gas station. She wasn't angry anymore. Anger was temporary and unproductive. She was focused, determined. She'd spent years on the bench seeing cases where people claimed police misconduct and struggled to prove it. Now she was on the other side, and she understood exactly how the system failed victims. She was going to make sure that system couldn't fail anyone else the same way. 6 months into litigation, the department's lawyers made their first serious mistake. During a deposition, they put forward Captain Vincent Cross, Kovac's direct supervisor, thinking he'd defend the department's training and oversight. Instead, under oath, Cross admitted he'd personally witnessed Kovac make questionable stops, but never filed formal reports because he didn't want to create paperwork that might hurt the officer's career. Judge Brennan's attorney let that statement hang in the air for a full 10 seconds before asking the next question. The deposition transcript read like a prosecution's dream. Cross had essentially admitted the department prioritized protecting officers over accountability. He'd seen problems and actively chose to hide them. When asked why, his answer was worse than silence. He said, "That's just how things worked. That everyone understood you didn't throw fellow officers under the bus over minor issues." Minor issues. That's what he called racially biased stops. The mayor received that transcript on a Thursday afternoon. By Friday morning, he was ready to settle. But Judge Brennan had a different plan. She didn't want money. She wanted change. Her settlement demands included a complete overhaul of the department's early warning system, mandatory bias training every 6 months, body camera footage review protocols, an independent oversight committee with subpoena power, and policy changes that required supervisors to document and investigate any pattern of complaints against officers. The city balked. Those demands would cost millions to implement and fundamentally alter how the department operated. Judge Brennan's response was simple. Take it or see you in court, where a jury will award me twice what this costs and mandate the same changes anyway. She was right, and everyone knew it. A jury would see the videos, hear about Kovac's history, learn about the complaints that were ignored, and come back with a verdict that would devastate the city's budget and reputation, far worse than accepting these terms. 3 weeks of negotiations followed. The city tried to water down every demand. Judge Brennan refused to budge on the substantive changes, though she agreed to extend implementation timelines to make them financially feasible. She also agreed to a monetary settlement that was surprisingly modest, just enough to cover her legal fees and compensate for the violation she'd endured. This wasn't about getting rich. It was about making sure this couldn't happen to someone without her resources and knowledge. The settlement was announced on a Tuesday morning. The press conference was packed with reporters, civil rights advocates, and community members who'd been following the case. Judge Brennan stood at the podium, composed and precise as always, and explained what had been achieved. She talked about systemic change, accountability, and the responsibility of those in power to use it wisely. She never mentioned Kovac by name. She didn't need to. Everyone knew this case was bigger than one officer. Kovac himself had been fired 4 months earlier, right after Cross's deposition made headlines. The department announced his termination with a brief statement about conduct unbecoming an officer. No details, no admission of wrongdoing. Just a quiet exit that let them pretend they'd handled the problem internally. But the personnel file told a different story. Kovac was fired not just for the arrest of Judge Brennan, but for the pattern of behavior that arrest exposed. Internal Affairs had finally done the investigation they should have done years earlier. They'd found everything Judge Brennan's lawyers had found: discriminatory stops, ignored complaints, warning signs that were never addressed. Kovac couldn't even fight the termination. His own body camera footage had destroyed any defense he might have mounted. His union rep took one look at the evidence and advised him to accept the firing and move on. There would be no arbitration, no appeal, no getting his job back. He was done in law enforcement forever. Some officers in the department were furious about the settlement. They saw it as the city throwing one of their own under the bus to appease activists. They complained the new policies would make it impossible to do their jobs, that they'd be second-guessed on every decision, that the oversight committee was just a witch hunt waiting to happen. But other officers, the ones who'd been doing their jobs correctly all along, welcomed the changes. They were tired of officers like Kovac making everyone look bad. They were tired of dealing with community distrust created by a few bad actors who never faced consequences. They understood that accountability protected good officers by weeding out bad ones. The implementation of the settlement terms took 18 months. The Oversight Committee was the most contentious piece. The department fought every aspect of its structure, trying to limit its authority and access. Judge Brennan's legal team threatened to go back to court multiple times before the committee finally launched with real power to investigate and make binding recommendations. The committee's first major action sent shockwaves through the department. They reviewed 3 years of body camera footage and identified 12 officers with concerning patterns. Not illegal necessarily, but problematic. Disproportionate stops of minorities, aggressive language, unnecessary escalation. These officers were flagged for additional training and closer supervision. 2 were eventually terminated after investigation revealed policy violations. The message was clear. The old way of doing things was over. But the real test came when the committee investigated a use of force incident that the department had already cleared as justified. An officer had tased a teenager during a traffic stop. The internal review found no policy violations. The committee disagreed. They looked at the full context, the officer's history, the lack of de-escalation attempts, and concluded the force was unnecessary. They recommended discipline. The police union exploded. This was exactly what they'd feared: outside civilians overruling trained officers and tactical decisions. They threatened legal action, work slowdowns, everything in their playbook. The committee stood firm and released their full report publicly. The community read it and saw detailed analysis explaining exactly why the force was unjustified. They saw an oversight process that actually worked. The pressure on the department became overwhelming. Eventually, the chief implemented the committee's recommendations. The officer received a suspension and mandatory retraining. More importantly, the incident led to policy changes about when tasing was appropriate. The teenager's family, who'd been considering a lawsuit, accepted an apology and settlement after seeing the committee take their concerns seriously. Judge Brennan watched all of this unfold from her chambers. She'd returned to the bench 6 months after the settlement, assigned to a different jurisdiction to avoid any appearance of bias in cases involving the department. Her colleagues treated her with a mixture of respect and awkwardness. Some admired what she'd done. Others thought she'd made their jobs harder by putting herself in the story rather than staying above it. She didn't care about their opinions. She'd done what needed to be done. 2 years after her arrest, Judge Brennan was invited to speak at a national conference on criminal justice reform. She accepted. Her speech focused on something most people didn't want to acknowledge. The system wasn't broken. It was working exactly as designed. It was designed to give enormous discretion to officers with minimal accountability. It was designed to protect law enforcement from consequences. It was designed to make it nearly impossible for victims to prove misconduct. Her arrest hadn't been an aberration. It was the system functioning normally. The only unusual part was that she had the knowledge and resources to fight back. She spoke about the dozens of people she'd sentenced over the years for resisting arrest or obstruction, wondering now how many of those arrests started exactly like hers did. She talked about the defendants who tried to explain they'd done nothing wrong, that the officer had no reason to stop them. She dismissed those claims as everyone did, assuming the officer must have had justification that simply wasn't articulated well in the report. Now she knew better. Those defendants might have been telling the truth. They might have been arrested for the same reason she was. For existing while black in a space where someone with a badge decided they didn't belong. The speech went viral. Conservative outlets attacked her for being anti-police. Progressive outlets celebrated her for speaking truth to power. She ignored both. She wasn't interested in being a symbol or a spokesperson. She was interested in results, in making sure the settlement terms were actually implemented and not just performed for show. 3 years post-arrest, the data started coming in. The department's stop patterns had shifted measurably. Officers were stopping fewer people overall, but those stops were more likely to result in actual enforcement action, suggesting they were better targeted. Complaints about discriminatory stops had dropped by 40%. Use of force incidents were down. The Oversight Committee had investigated 32 cases and found misconduct in 11 of them. Every single one of those findings led to discipline that stuck. The changes were working, but they were fragile. A new mayor could defund the committee. A new police chief could stop enforcing the policies. The union could negotiate away the reforms in the next contract. Judge Brennan understood this wasn't a permanent victory. It was a temporary shift that would require constant vigilance to maintain. That vigilance came from unexpected places. Community groups that formed during the controversy remained active, monitoring police interactions and documenting patterns. Law students volunteered to help people file complaints and navigate the process. Local journalists kept investigating, kept asking questions, kept holding officials accountable when they tried to backslide. Officer Vincent Hayes never fully recovered professionally. He left the department 18 months after the settlement, citing the hostile work environment created by what he called political interference in policing. He took a job 3 counties over as a deputy sheriff. Within 6 months there, he'd racked up 2 excessive force complaints. The pattern followed him because the pattern was him. Some people never learn. They just move. Judge Brennan saw him one more time, purely by chance. She was having coffee at a cafe when he walked in wearing his new uniform. Their eyes met across the room. He looked away first, grabbed his order, and left quickly. She wondered if he felt anything. Shame, anger, regret? Or if he'd convinced himself he was the real victim in all this. The financial cost of that arrest kept adding up in ways the city hadn't anticipated. The settlement was just the beginning. Insurance premiums for the police department increased dramatically. The city had to hire additional staff to manage the Oversight Committee. Training costs multiplied. Legal fees for defending other cases piled up as more people came forward with complaints, emboldened by Brennan's successful lawsuit. One city council member tried to calculate the total cost during a budget hearing. Between the settlement, legal fees, increased insurance, new positions, training programs, and lost productivity from officers on leave, the arrest had cost taxpayers somewhere between $3 and $4 million. $4 million because one officer couldn't handle being questioned by a black woman. But the human cost was harder to quantify. Judge Brennan dealt with symptoms that lingered long after the physical injuries healed. She'd be driving and see a police car behind her, and her heart would race. She'd be in court, and an officer would approach too quickly, and she'd feel her body tense. She started therapy 6 months after the arrest, something she'd resisted initially because she thought she could handle it herself. The therapist helped her understand that what she experienced was trauma, and trauma doesn't respond to logic or willpower. Her brain had learned that police officers were dangerous, and no amount of knowing better intellectually could override that learned response. It took time, practice, and patience to retrain those reactions. Her family struggled too. Her sister became hypervigilant about police interactions, pulling out her phone to record whenever she saw officers talking to anyone. Her nephew, 15 years old, developed intense anxiety about driving once he got his learner's permit. He'd witnessed his aunt's arrest on video and internalized the message that even doing everything right wouldn't protect him. Judge Brennan tried to shield them from her worst moments, but families share pain whether they want to or not. Her mother, 73 years old, told her she'd stopped watching the news because every police shooting, every wrongful arrest, every video of violence made her think of what could have happened that night. What nearly did happen. The broader community felt the ripple effects as well. Trust between residents and police, already fragile, deteriorated further. People stopped calling for help with minor issues, afraid any interaction might escalate. Neighborhood watch programs dissolved because nobody wanted to work with officers anymore. The police blamed activists and the media for poisoning community relations. They never seemed to consider that their own actions might be the actual poison. 4 years after her arrest, Judge Brennan was assigned a case that brought everything full circle. A young man, 26 years old, was charged with resisting arrest and assaulting an officer. The police report claimed he'd attacked them during a routine stop. The defense attorney presented Bodycam footage showing something completely different. The young man had asked why he was being stopped, and the officers escalated immediately, grabbing him when he didn't comply fast enough with contradictory commands. Judge Brennan watched the footage 3 times. She saw herself in that young man's confusion, his attempts to understand what was happening, his fear as the situation spiraled. The similarities were impossible to ignore. The defense attorney moved to dismiss based on lack of probable cause for the initial stop. The prosecutor argued the officers had reasonable suspicion based on the defendant matching a description. What description? Judge Brennan asked. The prosecutor pulled out the dispatch call. Black male, 20s to 30s, medium build, dark clothing. Judge Brennan looked at the defendant. She looked at the prosecutor. She asked if the prosecutor seriously believed that description justified stopping this specific person. The prosecutor hesitated, then fell back on officer discretion and training. Judge Brennan suppressed evidence obtained after the unlawful stop, which gutted the prosecution's case. She dismissed the charges entirely. The young man cried when she explained he was free to go. His mother, sitting in the gallery, sobbed with relief. The prosecutor looked furious but said nothing. What could they say? The law was clear, even if it was rarely applied this way. After court, the young man's attorney thanked Judge Brennan. She didn't want thanks. She wanted a system where judges didn't have to be personally victimized before they understood what defendants had been saying all along. She wanted prosecutors who cared about justice more than conviction rates. She wanted officers who saw people as people, not threats to be controlled. But wanting and having are different things. The case got attention because of Judge Brennan's involvement. Legal analysts debated whether her personal experience created bias that should have required recusal. Others argued her experience gave her insight that made her better equipped to evaluate these cases fairly. The State Judicial Ethics Board received complaints but found no violation. Judges aren't required to recuse themselves just because they have relevant life experience. Still, Judge Brennan knew some people would always question her rulings in police misconduct cases. They'd assume she was biased against officers, unable to be objective. The irony was thick. Nobody questioned whether judges who were former prosecutors were biased in favor of police. Nobody suggested judges who came from law enforcement families should recuse themselves. But a judge who'd been unlawfully arrested? Suddenly, objectivity was a concern. 5 years after that parking lot encounter, Judge Brennan received a letter. It came to her chambers, handwritten on lined paper. The return address was from a prison 2 states away. She almost threw it away without reading it, assuming it was from an inmate asking for help with their case. Something made her open it anyway. The letter was from Vincent Hayes. He was writing from prison, serving a 4-year sentence for assault. He'd beaten a suspect during an arrest at his new department, and this time, there were multiple witnesses and clear video. This time, he couldn't talk his way out. The letter wasn't an apology exactly. It was more of an explanation, a rambling attempt to justify his actions by talking about the stress of the job, the dangers officers face, the split-second decisions required. Judge Brennan read it twice, looking for any hint of genuine remorse or understanding. She found none. Even from prison, Hayes was defending himself, portraying his violence as unfortunate but understandable. He ended the letter by saying he hoped she'd forgiven him and moved on with her life. She burned the letter in her office fireplace. Some things don't deserve preservation. That same year, the Oversight Committee released its 5-year report. The data showed measurable improvement in nearly every category. Stops were down, but more legally justified. Complaints were down. Use of force was down. Officer discipline was actually happening when misconduct was proven. The report concluded that civilian oversight, combined with mandatory training and real consequences, could change police culture. But the report also noted the fragility of these gains. Reforms required constant maintenance and political will. Without continued pressure and attention, departments would drift back toward old patterns. The work was never finished. Judge Brennan knew this better than anyone. Her arrest had sparked change, but sustaining that change required effort from countless people doing unglamorous work. Filing complaints, attending committee meetings, analyzing data, training officers, investigating misconduct, holding officials accountable. Change wasn't a single dramatic moment. It was 1,000 small actions repeated over time. She thought about that often when people asked if her arrest was worth it, if the settlement and reforms justified what she went through. The question bothered her because it assumed her trauma was a price paid for progress, as if the universe required Black women to be brutalized before society would pay attention. Her arrest shouldn't have been necessary. None of it should have happened. And the fact that it took a federal judge being unlawfully arrested on camera before the system responded proved exactly how broken things were. Ordinary people had been saying the same things for decades, but their voices didn't matter until someone with power and credentials experienced it personally. That was the real injustice. Not just what happened to her, but what had been happening to countless others who didn't have her resources or platform. People who were arrested, beaten, or killed, and nobody cared because they didn't have the right credentials or connections. People whose complaints were dismissed, whose videos were ignored, whose lives were destroyed by officers who faced no consequences. Judge Brennan returned to that parking lot once, 6 years after the arrest. She sat in her car and looked at the spot where Hayes had thrown her to the ground. The pavement had been repaved since then. No physical evidence remained of what happened there. But she remembered every second. The shock, the pain, the rage, the fear. She remembered knowing that her life could end right there, over nothing, and nobody would be held accountable. She started her car and drove away. The past couldn't be changed, but the future remained unwritten. And she'd spend whatever time she had making sure that parking lot encounter meant something beyond her own pain. Making sure the reforms survived. Making sure other people didn't have to go through what she did before the system listened. Because if there was any purpose to be found in trauma, it was in preventing others from experiencing the same thing. That was the only justice that mattered. That's the weight of 31 minutes in handcuffs. A federal judge arrested for pumping gas while Black. An officer so convinced of his own assumptions that he ignored every piece of evidence contradicting them. A system so broken that it took someone with power being victimized before anyone paid attention. The reforms are real but fragile. The Oversight Committee still functions, still investigates, still holds officers accountable. But every budget cycle brings new threats to defund it. Every election brings politicians promising to get tough on crime by getting soft on police accountability. The work continues because it has to, not because it's finished. Officer Kovac never worked in law enforcement again. Judge Brennan still serves on the federal bench. Those facts alone don't constitute justice, but they're a start. Real justice would be a system where federal judges and ordinary citizens receive the same protection from unlawful arrests. Real justice would be officers facing consequences before someone with credentials and connections forces the issue. The gas station still operates on that corner. People pump gas there every day, unaware they're standing where a federal judge was handcuffed for asking questions. The cameras still record, the lights still shine, and somewhere, someone else is being stopped for matching a description that's really just code for their skin color. The Bodycam footage from that night remains sealed per the settlement agreement. But everyone involved knows what it shows. An officer seeing what he expected to see instead of what was actually there. A judge maintaining composure while her rights were violated. 31 minutes that cost millions of dollars and changed an entire department's policies. That's the price of assumptions. That's the cost of unchecked authority. And that's what happens when someone finally has the power to make the system answer for what it's been doing all along. Now, watching footage like this, it can really stick with you, right? Some of these clips stay in your head, especially late at night when you're trying to fall asleep. And speaking of sleep, a lot of you have told me you're waking up at 2 or 3 a.m. and just lying there. Can't shut your mind off. And the next day you're dragging through everything. I came across a simple 21-day sleep guide that's helped thousands of people fix exactly that. No pills, no apps, no gadgets. Just a step-by-step plan that actually works. It's only $15. I put the link in the description if you want to check it out. All right, I'll catch you in the next one.
Don't move! Drop it! On the ground, now!
I'm a United States immigration judge. My credentials are in my...
Think that badge makes you untouchable? We know your type. Fake papers, fake titles. Get down! Yeah, sure you are. Stay still! I got it on video.
At 5:46 a.m. on a quiet Wednesday morning in Bethesda, Maryland, 4 ICE agents in full tactical gear pulled into the driveway of a brick colonial home on a tree-lined street where nothing ever happened. They moved fast, fanning out across the property like they were executing a raid on a known fugitive. The woman they surrounded was standing beside her silver sedan, loading a leather briefcase into the back seat. She wore a pressed charcoal suit and low heels. Her hair was pulled back neatly. She was heading to work. She never made it past her own driveway. The lead agent drew his weapon and pointed it at her chest. "Get on the ground, now!" She stopped moving. Her hands rose slowly, palms open. "I'm a United States immigration judge. My credentials are in my briefcase." The lead agent didn't lower his weapon. He laughed, short and sharp. "Sure you are." His partner grabbed her arm and forced her down. Her knees hit the concrete first, then her chest, then her face. The briefcase fell open on the driveway, scattering judicial dockets and a Department of Justice credential across the pavement. They cuffed her with her cheek pressed against the cold ground, her glasses cracked beneath her, her suit jacket torn at the shoulder. She did not resist. She did not raise her voice. Across the street, a retired federal marshal named Leonard Abrams stood at his front window, phone already recording. He had spent 30 years in federal law enforcement and knew exactly what he was watching. "That's not a raid," he muttered. "That's an assault." The entire arrest took less than 3 minutes. The fallout would take years. The woman on that driveway was Judge Denise Oyewale, 52 years old, and she had earned every letter of that title through decades of work that most people couldn't imagine. Born in Lagos, Nigeria, she immigrated to the United States at age 9 with her parents, who arrived with 2 suitcases and a belief that this country rewarded discipline and education. She became a naturalized citizen at 18, the same year she graduated high school as valedictorian. She attended Howard University on a full academic scholarship, graduating top of her class, and then Columbia Law School, where she was elected to law review and graduated with honors. She clerked for a federal appellate judge in the Fourth Circuit, a position given only to the most exceptional law graduates in the country. After her clerkship, she spent 8 years as a public defender, specializing in immigration cases, representing people who had no money, no voice, and no one else willing to fight for them. Her record in that role was remarkable, winning cases that more experienced attorneys had written off as hopeless. At 40, she was appointed to the bench at the Arlington Immigration Court, one of the busiest and most scrutinized courts in the federal system. For 12 years, she had served with a reputation for fairness, legal precision, and rulings so well-reasoned that her overturn rate on appeal was among the lowest in the country. Attorneys on both sides of the aisle respected her. She lived alone in the Bethesda home she had shared with her late husband, Commander Isaiah Oyewale, a Navy veteran who passed 4 years earlier. She was meticulous, dignified, and private. And on that Wednesday morning, she was face down on her own driveway in handcuffs, bleeding from a scrape on her cheek, being treated like a fugitive by men who hadn't bothered to check whether they had the right person. The lead agent who ordered Judge Oyewale to the ground that morning was Supervisory Deportation Officer Craig Vanderhook, 44 years old, 15 years with Immigration and Customs Enforcement. Within ICE, Vanderhook was known for one thing above all else: numbers. He ran more field operations than any other supervisor in his region, logged more arrests per quarter, and built a reputation as someone who got results. His superiors rewarded that reputation with promotions, commendations, and the kind of institutional protection that came with being a producer. What they ignored was everything underneath. The DHS Office of Inspector General had flagged Vanderhook twice in 5 years for questionable arrests, once for detaining a legal permanent resident whose documents were in order, and once for executing an operation at the wrong address entirely. Both times, the cases were reviewed internally and closed without formal discipline. Colleagues had noticed a pattern they didn't talk about openly. Vanderhook's operations disproportionately targeted Black and African immigrants. The addresses he chose, the names he prioritized, the neighborhoods he hit first, always seemed to skew in one direction. No one filed a formal complaint. No one wanted to be the person who challenged a supervisor with Vanderhook's numbers and Vanderhook's connections. His team operated the same way. Agent Scott Pruitt, 36, had been with Vanderhook for 4 years. He mirrored his supervisor's aggression on every operation, never questioned a call, and treated Vanderhook's orders as final. Agent Domingo Farrell, 33, handled logistics and paperwork. He kept the files organized and the reports clean, and he had learned early that asking too many questions about operational decisions was a career-limiting move. Then there was Agent Tina Kowalski, 29, the newest member of the unit, just 7 months on the team. She had transferred in from a desk role, hoping for field experience. What she found instead was a unit that operated more like a personal squad than a federal team, where one man made every decision and 3 others followed without a word. Vanderhook stepped out of the lead vehicle at 5:47 a.m. with his weapon already drawn. The street was silent. No traffic, no dog walkers, just the faint sound of a sprinkler 2 houses down and the low idle of 2 unmarked SUVs in the driveway. Judge Oyewale had just placed her briefcase in the back seat of her sedan when Vanderhook's voice cut across the morning air. "Don't move. Drop the bag. Get on the ground." She turned slowly, hands rising instinctively. Her eyes moved from the weapon to the tactical vest to the ICE insignia on his chest. She did not panic. Her voice came out steady and clear. "I am Judge Denise Oyewale. I'm a United States immigration judge with the Arlington Immigration Court. You have the wrong person. I'd like to see a warrant." Vanderhook didn't pause. "We don't need a warrant. ICE operations don't require one. Get on the ground now." That statement was a distortion of the law, and he either knew it or didn't care. Pruitt moved behind her and grabbed her arm, pulling it back and forcing her downward. Her knees hit the driveway first, the concrete biting through her suit pants, then her chest, then her face. The sound of her glasses cracking against the pavement was sharp enough that a neighbor 2 doors down later said she heard it from inside her kitchen. Her briefcase had fallen open on impact, scattering court dockets, case files, and a laminated Department of Justice credential across the driveway for anyone to see. Pruitt planted a knee between her shoulder blades and held her there. Vanderhook looked down at the DOJ credential lying face up on the pavement. He picked it up, glanced at it, and tossed it back onto the ground. People fake these all the time. Kowalski stood 6 feet away, her hand resting on her vest, her body still. She said nothing. Her face showed everything. Farrell had already moved to the sedan and was searching the interior without consent, pulling open the glove box, checking beneath seats, rifling through a bag in the trunk. He found nothing because there was nothing to find. By now, 3 neighbors were recording from porches and windows. Across the street, Leonard Abrams, 68 years old, retired federal marshal, held his phone with one hand and dialed 911 with the other. His voice was calm and precise. "I need to report federal agents assaulting a federal judge in her own driveway. No warrant presented. She is compliant and on the ground. Send local police immediately." They lifted Judge Oyewale off the driveway and placed her in the back seat of the lead SUV, still cuffed, her wrists pressed together behind her back with the metal biting into her skin. The door shut hard. No one offered an explanation. No one read her rights. No one acknowledged the DOJ credential still lying on the pavement beside her scattered case files. Inside the vehicle, she sat upright, posture straight despite the pain in her knees and the sting on her cheek where the concrete had scraped the skin raw. She spoke clearly. "Who are you looking for? I want to know the name on your operation order." Vanderhook, seated in the front passenger seat, didn't turn around. She tried again. "I'm requesting your names and badge numbers. I have a legal right to that information." Pruitt, behind the wheel, glanced at her in the rearview mirror. "Stop talking or it gets worse." The drive to the ICE field office took 12 minutes. During those 12 minutes, the body camera mounted on Kowalski's tactical vest was recording. It captured the interior of the vehicle, the audio, the voices. It captured Vanderhook leaning back in his seat, relaxed, and saying to no one in particular, "Another one pretending to be somebody. These Africans always have fake papers." Farrell, seated beside Kowalski in the back row, laughed. A short, careless laugh. The kind of sound a person makes when cruelty has become routine. Kowalski sat still. Her camera kept rolling. She said nothing. At the field office, Judge Oyewale was walked through a side entrance and placed in a processing hold. A bare concrete room with a metal bench, fluorescent lighting, and a steel door. It was the same room used for immigration detainees awaiting transfer or removal proceedings. She was fingerprinted. Her photograph was taken. She stood in front of a height chart in a torn suit with a scraped face and broken glasses, processed like someone who had crossed a border illegally, not someone who had spent 12 years deciding those very cases from the bench. When the processing officer asked her name, she answered, "Judge Denise Oyewale, Arlington Immigration Court, Department of Justice." The officer's hands stopped moving. He looked at her, then at the screen, then back at her. He set down his pen, stood without a word, and left the room. He came back 2 minutes later with a supervisor. Deputy Field Office Director Nathan Solis was at his desk reviewing overnight reports when the processing officer appeared in his doorway, pale and speaking fast. Solis listened for 10 seconds, then turned to his terminal and typed in the name. Oyewale Denise. The federal system returned results immediately. Judicial appointment confirmed. Department of Justice credential number active. Naturalization certificate filed and recorded. Immigration judge, Arlington Immigration Court, 12-year tenure. Solis stared at the screen for a long moment. Then he stood and walked down the hallway to the processing hold. He opened the steel door and saw her. A sitting United States immigration judge in a wrinkled charcoal suit, one cheek raw and swollen, glasses cracked and sitting crooked on her face, wrists red from cuffs, seated on a metal bench between 2 immigration detainees who had been picked up overnight. She looked up at him with an expression that wasn't anger. It was something worse. It was recognition. The recognition of someone who had spent her career inside this system and was now being consumed by it. Solis uncuffed her himself. His hands were not steady. "Ma'am, I am deeply sorry." He asked where Vanderhook was. He was told the break room. Solis found him there, leaning against the counter, eating a breakfast sandwich, scrolling through his phone. Solis kept his voice low, but the edge was unmistakable. "Do you know who you just brought in?" Vanderhook didn't look up immediately. Address matched, description matched. Clean grab. Solis stepped closer. The address did not match. The name did not match. "The target on your operation order is a 28-year-old male from Guatemala named Raul Cifuentes. You arrested a 52-year-old woman from Nigeria. A federal judge, Craig. A sitting immigration judge with the Department of Justice." Vanderhook finally looked up. His expression shifted, but only slightly. "So we'll cut her loose. Happens sometimes." Solis shook his head slowly. "No, this doesn't just happen. Nothing about this matched. Not the gender, not the age, not the nationality, not the name, not the address. You had no warrant, no probable cause, and no legal basis for this arrest. And you put a federal judge face down on her own driveway." Vanderhook set down the sandwich. For the first time that morning, something behind his eyes changed. Not remorse, not guilt. Just the first faint recognition that this one might not go away quietly. Deputy Field Office Director Solis escorted Judge Oyewale to a private office, offered her water, a first aid kit, and a phone. She declined the water. She cleaned the scrape on her cheek herself, pressing a gauze pad against the raw skin with steady hands. Then she picked up the phone and began making calls. The first went to Chief Immigration Judge Sandra Levesque at the Arlington Immigration Court. Oyewale spoke for less than 2 minutes, her voice controlled and precise, recounting the arrest, the driveway, the cuffs, the processing hold, the concrete room. Levesque listened without interrupting. When Oyewale finished, Levesque said one sentence: "I'm calling the Attorney General's office now." The second call went to the Executive Office for Immigration Review, the federal body that oversees all immigration courts. Oyewale filed a formal incident report by phone, detailing the agents involved, the time of arrest, and the absence of any warrant. The third call went to the Department of Justice Office of the Inspector General. Oyewale requested a formal investigation into civil rights violations, excessive force, and unlawful detention by ICE personnel. The fourth call went to her personal attorney, a former federal prosecutor named Victor Langston, who had spent 20 years handling civil rights cases at the highest levels. She told him what happened. He told her not to make any public statements and that he would be at her home within the hour. Within 90 minutes of her release, the chief immigration judge had notified the Attorney General's office directly. The DOJ Civil Rights Division had been alerted and was assembling a preliminary review team. The DHS Office of Inspector General had opened a formal inquiry. Leonard Abrams' video, recorded from his window across the street, was already circulating among federal law enforcement contacts, shared by retired agents who recognized exactly what it showed. By noon, 3 members of Congress had been briefed by staff. The facts were simple and devastating. A black female federal judge had been dragged from her driveway, forced to the ground, cuffed, scraped, detained, driven to a field office, fingerprinted and photographed in a processing hold alongside immigration detainees. Without a warrant, without matching identification, without any lawful basis whatsoever. The political and legal shockwave was instantaneous, and it was still building. Back at the field office, the mood had shifted. The hallways that had been routine and busy that morning were now quiet in the way that buildings get quiet when people realize something very bad has happened and no one wants to be standing too close to the people responsible. Vanderhook felt it. He saw it in the way supervisors avoided eye contact, in the way the processing staff whispered near the front desk, in the way Solis had looked at him in the break room. He pulled Pruitt and Farrell into a small conference room on the second floor and closed the door. "We need to clean this up," Vanderhook said. His voice was steady, but the ease from earlier that morning was gone. "The operational report needs adjustments." He laid out the plan. Change the stated address in the report to more closely match the target's last known location. Add language stating that Oyewale had been uncooperative during initial contact and had made sudden movements toward her vehicle, suggesting possible concealment. Include a note that she had physically tensed and pulled away when agents attempted to restrain her. Language that would reframe the use of force as reactive rather than initiated. Pruitt nodded without hesitation. Farrell shifted in his seat but said nothing against it. Then Vanderhook called Kowalski into the room. She stood near the door, arms crossed. "Your body cam," Vanderhook said. "It malfunctioned. You noticed it wasn't recording during the operation. That's what you'll say." Kowalski's jaw tightened. She looked at Pruitt, who stared at the table. She looked at Farrell, who looked at the wall. "Craig, I don't think—" Vanderhook cut her off. "If you don't back us on this, you'll be the one holding the bag. You were there. You didn't intervene. You think they'll see you as innocent?" The altered report was submitted by end of day, signed by Vanderhook and co-signed by Pruitt. It described a compliant but tense subject who matched a known operational profile. It made no mention of a DOJ credential, no mention of judicial status, no mention of a weapon drawn on an unarmed woman loading her briefcase into a car. But what Vanderhook did not know, what none of them knew, was that Kowalski's body camera footage had already been automatically uploaded to the DHS cloud server. A new digital evidence policy implemented 6 months earlier required all body camera files to sync to a secure federal server within minutes of deactivation. The footage could not be deleted, altered, or overridden at the field level. And it had captured everything. The driveway, the knee on her back, the racial comments in the SUV, the processing hold, and now, the conversation in which Vanderhook had instructed a fellow agent to falsify evidence and lie about her own equipment. Every word, every instruction, every second of it preserved on a server he couldn't touch. The DHS Office of Inspector General moved fast. Within 48 hours, federal investigators arrived at the field office and began pulling everything. Kowalski's body camera footage came first, automatically uploaded to the DHS cloud server, time-stamped and unedited. They watched it in sequence. The driveway, the weapon drawn on an unarmed woman, her voice identifying herself as a judge, the force that followed anyway, the knee on her back, the DOJ credential tossed on the ground. Then the SUV. Vanderhook's voice saying these Africans always have fake papers. Farrell's laugh. Kowalski's silence. Then the conference room. Vanderhook instructing Kowalski to claim her camera malfunctioned. They pulled the neighbor videos. 3 recordings from 3 angles showing the same thing. A compliant woman forced to the ground without resistance or threat. They pulled Abrams' 911 call, precise and damning. Then they placed Vanderhook's altered report beside the footage. Every material claim was contradicted. The report said she was uncooperative. The footage showed immediate compliance. The report said sudden movements. The footage showed raised hands, palms open. The report omitted her credentials. The footage showed Vanderhook holding her DOJ badge and dropping it. Internal Affairs interviews began the next day. Kowalski, confronted with footage of Vanderhook pressuring her, cooperated fully. She provided a sworn statement detailing the arrest, the racial comments, the cover-up, and Vanderhook's pattern of targeting African immigrants across multiple operations. Farrell hired an attorney and declined all questions. Pruitt invoked his rights and sat stone-faced through 2 interviews. Vanderhook retained a private defense attorney who issued a statement claiming the arrest was conducted in good faith based on available intelligence. The investigators read it, looked at the footage, and moved forward. Good faith did not survive contact with the evidence. Leonard Abrams' video reached the press on a Thursday evening. By Friday morning, the story had broken nationally. Every major outlet carried it. A sitting United States immigration judge, a naturalized citizen, a black woman, a 12-year veteran of the federal bench, arrested in her own driveway by ICE agents who claimed she matched the profile of a 28-year-old Guatemalan man. The absurdity of the mismatch eliminated any credible claim of honest error. A 52-year-old woman mistaken for a 28-year-old man. a Nigerian-born citizen mistaken for a Guatemalan national, a federal judge mistaken for a fugitive. The gap was so vast it left only one explanation. She was black. She was in her driveway, and that was enough. Civil rights organizations responded within hours. The NAACP called it a grotesque abuse of federal power. The Congressional Black Caucus demanded a full, independent federal investigation and called for congressional hearings into ICE oversight failures. The National Association of Immigration Judges issued an unprecedented joint statement condemning the arrest as a direct attack on judicial independence. Immigration attorneys across the country signed an open letter demanding accountability. Protests formed outside ICE field offices in Washington, Baltimore, and New York. The footage played on cable news on a loop. The image that stayed longest was the still frame from Abrams' recording. A black woman in a charcoal suit, face down on her own driveway, a DOJ credential lying on the pavement 3 feet from her head. The story dominated the news cycle for a full week, and it was still building. The joint preliminary investigation by the DOJ Civil Rights Division and DHS Office of Inspector General was completed in under 3 weeks. The findings were unambiguous. The arrest of Judge Denise Oyewale had no legal basis. No valid warrant had been obtained or presented. No matching suspect description existed. The target on the operational order was a 28-year-old male from Guatemala. The person arrested was a 52-year-old female federal judge from Nigeria. The force used was excessive against an individual who was fully compliant from the moment of contact. The falsified operational report submitted by Vanderhook and co-signed by Pruitt constituted obstruction of a federal investigation. The racial comments captured on Kowalski's body camera constituted direct evidence of bias-motivated conduct. The instruction to falsify body camera records constituted conspiracy to obstruct. The suspensions came the same day the findings were delivered. Vanderhook, suspended without pay. Pruitt, suspended without pay. Farrell, suspended without pay. Kowalski was placed on administrative leave with pay, her cooperation noted and her status held pending final review. Firearms were confiscated. Credentials were deactivated. Access to all federal systems was revoked. The U.S. Attorney for the District of Maryland convened a federal grand jury the following week. Witnesses were called. Evidence was presented. The body camera footage was played in its entirety. Within 2 weeks, indictments were returned against Vanderhook, Pruitt, and Farrell. The charges were severe. Deprivation of rights under color of law under 18 U.S.C. Section 242. Conspiracy against rights under 18 U.S.C. Section 241. Obstruction of justice. Filing false federal reports. Each charge carried significant prison time. Combined, the maximum exposure for Vanderhook alone exceeded 20 years. The federal trial began on a Monday morning in a packed courtroom in Baltimore. Prosecutors opened by playing the body camera footage and the neighbor recordings in unbroken sequence. The courtroom watched in silence as Judge Oyewale was ordered to the ground, forced onto the concrete, kneed in the back, and cuffed while calmly identifying herself. They heard the glasses crack. They heard Vanderhook dismiss her DOJ credential. They heard the SUV recording. These Africans always have fake papers. They heard the conference room recording. Vanderhook instructing Kowalski to lie. Kowalski took the stand and testified in detail. She described the pressure to falsify her body camera record, the racial remarks she had witnessed across multiple operations, and the unit culture that made questioning Vanderhook professionally dangerous. She was calm, specific, and consistent under cross-examination. Leonard Abrams testified next, describing what he saw from his window that morning. A federal judge treated like a fugitive on her own property by agents who never checked whether they had the right person. Then Judge Oyewale took the stand. She described the terror of being forced to the ground in her own driveway at dawn, the humiliation of being fingerprinted and photographed in a concrete hold room beside immigration detainees. The moment she understood these agents had no idea who she was and did not care. She described the scrape on her cheek that took weeks to fully heal, the glasses she had to replace, the nights afterward when she could not sleep in her own home because every sound outside her window triggered the memory of boots on her driveway. The defense argued good faith operational error. Prosecutors dismantled this in minutes, displaying the suspect profile beside Judge Oyewale's photograph on the courtroom monitors. A 28-year-old man next to a 52-year-old woman. The jury looked at the images. There was nothing left to argue. They deliberated for less than a day. The verdicts came back the same afternoon. Guilty on all counts for Craig Vanderhook. Guilty on all counts for Scott Pruitt. Farrell, who had cooperated partially during the trial and whose attorney had negotiated limited testimony in exchange for consideration, was found guilty on reduced charges. The courtroom was still when the foreperson read each verdict. Vanderhook stared straight ahead. Pruitt's head dropped. Farrell closed his eyes. Sentencing followed 6 weeks later. The presiding judge, a veteran of the federal bench with more than 2 decades of experience, did not temper his remarks. He called the arrest of Judge Oyewale one of the most egregious abuses of federal authority this court has seen. He cited the racial language, the fabricated report, the obstruction, and the complete absence of any lawful basis for the operation. He noted that the defendants had not targeted a stranger by accident. They had targeted a sitting federal judge and still could not recognize her humanity, even after learning who she was. Vanderhook was sentenced to 6 years in federal prison. Pruitt received 4 years. Farrell received 2 years. All 3 were permanently barred from federal employment. Their law enforcement certifications were revoked. They would never carry a badge again. Kowalski, whose cooperation had been critical to the prosecution, avoided criminal charges. She resigned from ICE voluntarily the week after the trial ended. 3 months later, she testified before a congressional subcommittee about the internal culture that had enabled Vanderhook's conduct, the silence, the complicity, the unspoken understanding that certain targets were chosen for reasons no one put in writing. 2 supervisors who had approved Vanderhook's operations without adequate review were formally demoted and reassigned to administrative roles. Neither was terminated, a fact that drew sharp criticism from oversight groups who argued the accountability had not reached high enough. Judge Oyewale filed a federal civil rights lawsuit against ICE, the Department of Homeland Security, and the 3 individual agents. The case cited unlawful arrest, excessive force, racial profiling, false imprisonment, and violation of judicial independence. Her attorney, Victor Langston, built the case methodically, but it was discovery that delivered the most damaging material. Internal records revealed that Vanderhook's unit had conducted 19 prior field operations with strikingly similar patterns: wrong addresses, mismatched suspect descriptions, disproportionate targeting of Black and African immigrants in neighborhoods where the actual targets had no known connection. 8 of those operations had generated formal complaints from the individuals detained. None of those complaints had been investigated. They had been filed, noted, and buried, treated as routine friction rather than evidence of a pattern. Langston presented these records alongside Kowalski's testimony and the body camera footage from the Oyewale arrest. The cumulative picture was devastating, not just for the agents, but for the institution that had employed, promoted, and protected them. The government settled before trial. The amount was reported to be in the multi-millions, though the exact figure was sealed. More significant than the money were the mandatory reforms attached to the settlement. Independent review of all ICE field arrest operations nationwide. Mandatory warrant verification protocols requiring supervisory sign-off before any residential arrest. Automatic body camera upload to federal servers with no agent-level override or deletion capability. And the creation of a DHS Civil Rights Compliance Unit with external civilian oversight and the authority to investigate complaints independently. Legal scholars and civil rights organizations cited the settlement as a landmark in federal law enforcement accountability. Not because the system had worked perfectly, but because for the first time, the consequences had reached deep enough to force structural change, rather than just individual punishment. Judge Denise Oyewale returned to the bench on a Tuesday morning, 6 months after the arrest. She arrived early, as she always had, parked in the same lot, carried the same leather briefcase, and walked the same corridor to her courtroom at the Arlington Immigration Court. The only visible difference was a new pair of glasses. The scrape on her cheek had healed, though a faint mark remained if you knew where to look. When she entered the courtroom and took her seat, something unusual happened. Every attorney present, government counsel and defense attorneys alike, stood. It was not required. It was not prompted. It was a gesture of solidarity that rippled through the room in silence, and Judge Oyewale acknowledged it with a single nod before calling the first case on her docket. She issued no public statements about the arrest, the trial, or the settlement. She gave no interviews. She made no appearances on cable news, despite dozens of requests. She let the legal record speak because she believed the legal record was enough. Quietly, using a portion of the settlement, she established the Oyewale Legal Scholarship Fund, providing financial support to immigrant students pursuing law degrees at Howard University and Columbia Law, the two institutions that had shaped her career. Leonard Abrams, the retired federal marshal who had recorded the arrest from his window and called 911 while it was still happening, received the Community Service Commendation from the Department of Justice. He attended the ceremony in a suit he hadn't worn in years and said very little afterward. When a reporter asked him why he had started recording that morning, he said, "Because I knew what I was seeing, and I knew no one would believe it without proof." Craig Vanderhook began his 6-year sentence at a federal correctional facility in West Virginia. He never apologized. Not to Judge Oyewale, not to the court, not publicly. His name became a case study in federal law enforcement training programs across the country, taught alongside the footage his own team had recorded. A training bulletin circulated through DHS the following quarter. It carried a single still image from Kowalski's body camera, a black woman in a charcoal suit, face down on her own driveway, 4 agents standing over her, a DOJ credential lying open on the ground beside her broken glasses. The caption beneath read, "This is what failure of mission looks like." No names were printed on the bulletin. They didn't need to be. The careers were already gone. Now, watching footage like this, it can really stick with you, right? Some of these clips stay in your head, especially late at night when you're trying to fall asleep. And speaking of sleep, a lot of you have told me you're waking up at 2 or 3 a.m. and just lying there. Can't shut your mind off. And the next day you're dragging through everything. I came across a simple 21-day sleep guide that's helped thousands of people fix exactly that. No pills, no apps, no gadgets. Just a step-by-step plan that actually works. It's only $15. I put the link in the description if you want to check it out. All right, I'll catch you in the next one.